project, we decided to focus on how lies and changes in testimonies can impact case proceedings and outcomes. We asked 5 civil legal service lawyers questions about how they deal with lies in court cases and how they impact their cases and the work they do. These lawyers specialize in cases with civil legal issues for persons who are underprivileged, including domestic violence victims, people recovering from substance abuse, and people with unstable housing.
Your Honor, my client is an excellent parent.
Oh yeah? Why?
Because I said so.
Many lawyers do often rely on witness testimonies in court. When we talk about court, we mean a place where people try to understand what happened. One important thing is when people tell their stories, and we call it witness testimony. This is a big deal because sometimes there is not much other evidence. Legal experts say that those stories matter a lot. It's essential to figure out if the people talking in court are telling the truth or not. What they believe is also important. Think of it like putting together a puzzle or understanding a story. Even if there are not many things you can see, the words people use are really important. If you might be on a jury one day, it's essential to know that really paying attention to what people say is super important. It's not just about hearing the words. Even if there is not much to say, what people say is a big deal in making fair decisions. What did you think when you saw the bruises first?
Honestly, I didn't know what to think. I didn't find out until later.
What did you think when you saw the bruises first?
Oh, I knew that he hit her.
There are a lot of sources of inconsistencies in witness statements. Human memory is not perfect. A lot of events are remembered differently by people who all experienced it. When testifying as a witness, it's also a very stressful time. It will have inconsistencies. Some people straight out lie, and that is when you see that they contradict themselves from something they said previously. In domestic abuse cases, a lot will lie and rewrite the story in their own mind so they do not look like they did anything wrong. They lie to benefit themselves. That's why it's important for lawyers beforehand to discuss possible questions, not to lead the witness, but to make sure they have their facts right.
I always pay my rent on time.
That's not what you told me in the record last time.
Oh, it's not?
The lawyers recognize that emotion can play a big role in handling changing in witness testimony. Emotion can be the reason why witnesses might change their story. It's not just about the facts, it's about how people feel and being prepared with tools, tactics, and strategies to handle the change in the witness testimony. Talking to witnesses before hearing can prevent surprise and changes in the testimony. Preparation seems to be a common strategy. There's a shared understanding that legal professionals can use certain records, like police reports, to help jog a witness's memory. It's like having tools to piece together the truth. The shared goal is to clarify and correct, ensuring the truth comes out in the end.
Let's talk about your substance use disorder. You were addicted to cocaine, and you claim you're sober, but you aren't doing anything to ensure you don't relapse when you're caring for your son, and you aren't in a recovery program, so you just rely on yourself to make sure you stay sober?
Lawyers deal with possibilities of opposing witnesses lying. Different people have different ways of dealing with it. Sometimes lawyers have previous exhibits that can be used to impeach the witness when they lie in court. It can be used to show the jury that the witness has inconsistencies and that their word's not fully accurate all the time. Impeachment is when a lawyer points out the lie to the trier of the fact. Cross-examination is important. People tend to lie a lot in family court because they believe in the lie due to their perception being skewed by emotional ties. When cross-examining, lawyers tend to use yes or no questions and catch them on their lies. Overall, there's a lot of preparation that is needed in order to deal with lying from an opposing witness.
I swear I've never done drugs in my life.
Oh well, I'm gonna go.
Lawyers have to follow strict rules that stop them from using lies in court. If a lawyer thinks their client or witness might lie, they have to tell them to be honest. If they don't trust a client, lawyers might stop representing them to keep their honesty. Lawyers talk to their clients about how lying in court can cause problems. They explain that lying can ruin the case and lead to legal trouble, and they don't let witnesses they think will lie speak in court. But if they can't fix a lying issue, lawyers may quit the case. Their decision depends on how important the lie is to the case. If a client wants to speak in court even though they might lie, lawyers will ask them few questions to avoid breaking the law. They have a formal talk in pre-court to make sure the clients know the risk of lying.
It's okay, take your time.
Clients or witnesses behave differently before the judge rather than in private meetings. It can go both ways, with witnesses being emotional in the personal meetings and then being composed in the courtroom. The courtroom can be a stressful place, and many people do not know how to deal with the pressure that is brought upon them. Clients acting differently in the courtroom rather than meeting in private can negatively impact the case because it can make the case seem weary. When a witness becomes emotional or forgetful, the lawyer tends to give them time and get their point across calmly with simple questions. The job of the lawyers is to represent their client to the jury, and not the outcome of the case.
Don't worry, he has to get through me first.
My hero.
This focuses on how lawyers assist clients that are victims due to the presence of their abusers, particularly in situations where they face their abuser in court. Lawyers often stand between the victim and the abuser in court to create a sense of safety. They also tell them that the courtroom is a safe place, because there are court officers there. Thorough preparation for the court is important. This involves discussion, courthouse security, where to sit, and how to indicate problems or inconsistencies in testimonies. Emotional coaching is also provided to help victims remain composed and communicate effectively with the judge. In some areas, victims of domestic violence can participate in court proceedings remotely, avoiding direct confrontation with the abuser. If remote participation isn't available, lawyers encourage victims to focus on them rather than the abuser during their testimony.
They will rue this day. Vengeance will be mine.
Hi, I'd like to file an appeal, please.
If a false testimony resulted in a lawyer losing the case, they can normally file an appeal or submit evidence to the court and request the matter to be reconsidered. However, with filing an appeal, it can be difficult because the evidence has to be valid and there is no testimony, only written evidence. Another option is to file a motion to reopen a record if the lawyer has new evidence suggesting that the record is not complete.
I may not know what I had for breakfast, but I do know for a fact that Bob stabbed Marisa in the eye.
If you take away anything from this, know that humans are imperfect and memory fallible. It is a very human thing to remember events in ways that cast ourselves or our circumstances in a positive light. The little details and unintentional lies do not matter when compared to the major facts of the case. Most people have practiced their statements enough that lying is unlikely. But since some people still lie and are good at lying, it is key to prepare as much as possible with your witnesses and with the case. Unless you know the case and the witnesses, you cannot anticipate one's motivations to lie or to tell the truth. Hard work wins the case in the end.